um prazer estar junto com os nossos panelistas e com grandes amigos aqui do IBRAC. É uma pena que estamos distantes, mas acho que é uma medida necessária no momento. Espero que no próximo ano a gente possa estar juntos. E aí, Rafik, having caipirinhas together after the panel. Eu gostaria de fazer algumas considerações. Eu vou fazer o painel, vou conduzir o painel em inglês, porque a maior parte dos nossos palestrantes falam em inglês. Pedindo já dizendo ao doutor Alexandre que fique absolutamente à vontade para responder em português, se sentir mais à vontade, na medida em que você e eu somos os únicos Portuguese speakers aqui. Como o Bruno disse, nós vamos tratar, I was just explaining, dear panelists, that I'm going to conduct the panel in English in the benefit of the majority of the speakers, but Alexandre will be free to speak in English or in Portuguese. So as Bruno mentioned, the idea here in the panel is to discuss the standard of proof in merger control cases, specifically in complex merger control cases, which may sound a very obvious subject, but currently it's a hot topic, given the recent decisions issued by antitrust authorities on a global level, in which theories of harm, standard and burden of proof, specifically under an economic perspective, are being discussed and challenged in using these standards beyond the reduction in the number of players or in the analysis of resulting market shares. And this is specifically important in this current moment of economic crisis, in which concentrations are occurring in a significant level, and so the authorities and us, lawyers and economists, are deeply involved in all these discussions. But the inspiration to this panel came from this recent decision from the European General Court that overruled, this decision was issued in May 2020, early this year, and it annulled an European Commission decision in a transaction that was ruled in 2016 between Telefónica UK and Hutchinson 3G UK. And in that decision, first of all, I want to make a disclaimer here that we don't want, and it's not the goal of the panel to discuss the merits of the decision itself, nor the impacts of the transaction in terms of market assessment, but rather to discuss the possibility of having an antitrust authority decision being challenged and overruled by the court. And another disclaimer is that we also acknowledge that this is not the first case in which a European Commission decision was overruled by the European Court. But this specific decision is particularly important because it was the first time that the General Court discussed or addressed the legal test of significant impediment to effective competition. And in the sense that this concept was challenged and discussed in details by the court to overrule the decision. And this is one of the reasons why we thought that this discussion would be relevant, and we discussed and decided to invite all these panelists from several parts of the world, and both economists and lawyers to help us to go over this decision and the impacts of this decision in the evaluation of merger control cases that are currently under discussion. So our dear panelists here are Mr. Alexandre Cordeiro, que dispensa apresentações. He is the General Superintendent at CADE. Rafik Bashur, he's a partner at Freshfields in Brussels. Cristina Caffarra, an economist from Charles River Associate, also based in Europe. And Maureen Olhansen, she chairs Baker Bott's Global Antitrust and Competition Practice in the US. And she's also a former FTC commissioner. So thank you for all of you to having accepted the invitation for this panel. We are very, very happy and honored by having you here to enrich our discussion on this topic. And just to introduce the discussion, and of course, I'm not an expert in the EU law, so Rafik and Cristina will be the ones to explain to us in details the impacts of this decision at the European level, and Maureen will bring us the US view on this. And of course, Alexandre will provide us with his views on how all these discussions of having antitrust authorities being discussed in different levels are impacted by this decision. So, a brief description of what were the basis of the European Commission decision, and a brief description of what were the basis for the courts to overrule the European Commission decision. So the EC decision basically is stated that economic studies should be assessed with caution. And again, this is a very brief description, but just to have everyone on the same page about the topics that were addressed. The second point is that the Commission said that 4 to 3 players tend to lead to price increase, reducing choice and quality. The third point is that mergers of this size, of big size in concentrated markets, tend to have no effects of industry level investments. And the fourth point is that the Commission rejected behavioral remedies, which were deemed too complex to implement and to monitor. Then the General Court decision stated that solely reducing competitive pressure on competitors in the market is in principle not sufficient in itself to constitute a significant impediment to effective competition, meaning that the standard of proof should be much higher. Therefore, absent dominance and collective dominance, it must be demonstrated with a strong probability the existence of significant impediment to effective competition following the concentration, including the possibility of price increases. Going from 4 to 3 is not prohibited per se. A case-specific, gradual assessment is required. Assumptions should not be the basis of a decision. Then, this being said, providing the audience and the panelists with this very brief frame of the decisions, I start with Rafik, giving him and all of you the opportunity to make opening remarks. But I would like, Rafik, to listen from you, your views on what are the lessons learned from this decision from the European Court. How does this impact the manner in which we should, or at least in Europe, you should advise our clients as regards complex merger cases and the possibility of having the antitrust commission, the antitrust decision being challenged by courts?
Thank you, Christiana, and hello, everyone. Thanks to IBRAC for the invitation as well. I think these invites are much more exciting when they're in person and we can actually go to Brazil and have a caipirinha or two, but we'll make do in the circumstances, of course, over Zoom. What I thought we'd do before going into what are the lessons learned from the decision, maybe just spend a minute or two with a bit of background as to the European process itself, because that helps put things into context a little bit. The European process, and I'm talking here about the European Commission, so at sort of at federal level rather than at national level, at member state level, which are quite similar, but the focus here is very much on the federal level. It's a very administrative process. So you've got the Directorate General of Competition within the European Commission, which we always refer to as the Commission, is investigating, prosecuting, and passing judgment. It's the same body that's going through that process. Very different in other parts of the world. It also has a burden of drafting quite a detailed decision on where it comes out, whether it wants to block a deal, whether it wants to clear a deal. That, in a way, puts an effort on the Commission to have to justify, obviously, the decision that it's taken, why it intervened or why it didn't intervene or why it accepted remedies. But it also opens up the Commission to challenge, either by the merging parties to the deal itself, or indeed by third parties who are incensed by the Commission's decision. They thought the Commission got it wrong. These challenges we don't see very, very often, and we can come on to that in due course as to why, but nonetheless, the decision can be challenged at the end of the day. I think it's fair to say that the Commission, as with any other authority, does not like to be challenged, and you can understand why, and does not in particular like to lose in court, which of course you can understand why. So there is in a way, if you wanted to be generous, you'd say there is a certain self-policing type process here for the Commission to have to get it right according to the way the Commission's reviewed it. Now, whether that's reached the right decision or not is a different topic. In terms of, yes, there has been this appeal in the telecoms case. A couple of years before that, there was the UPS TNT appeal, where the Commission's prohibition decision again was challenged, and it lost its decision. Prior to that, it's been, from memory, I would say at least 8 years prior to any previous challenge, which is a very long period of time. In the early to mid noughties, I would say there were a number of decisions where the Commission did suffer defeat in court. And that was during a period of time where the use of economic evidence in Europe was increasing in merger reviews. And in light of those two facts, sort of the loss at court at several decisions, and the fact that the prevalence of economic evidence is increasing, the Commission did create the post of a chief economist unit at DG Comp. And the purpose of that is to have the experts, the economists at the Commission, who are able to work hand in hand with the case team reviewing the transactions. But more importantly, I would say to act as an independent advisor to the Commissioner on where the case is going and where it should be going by reference to economic analysis. So it was a checks and balances type approach. I think over the years, there's some questions that are being asked out there as to whether the use of economic evidence and the unit of the chief economist unit is there fulfilling this checks and balances type role, or whether they are being leaned on by the case team to reach the objective that the case team particularly wants to achieve. It's a debate that you hear every so often. I'm not going to comment on it one way or the other, because ultimately it really depends from one case to the next as to where you'd come out. But that is a debate that is out there. I think in terms of the appeal itself and the lessons learned, I think primarily from my perspective, I would say it's a good thing that there was an appeal, because going through an administrative process, the one I just described, and having years and years and years of the Commission not being challenged, it just is not right from my perspective. I think it is important for courts to intervene. I think it is important for courts to draw the line as to how the law should be interpreted and set some precedents in that regard. So I think I would more encourage more type of appeals, and I'm encouraged myself by having more appeals out there. The practicality of it is something different, which we can come on to in due course. Now, as to the sort of the lessons learned from the case itself, and again, Chris, we're not going to focus on the facts of the case, and we need to look at it from a broader application, not just looking at the telecom sector as a whole. I think the first point I would make is that the courts have basically signaled to the Commission, again, after a long period of quietness, I would say, that the court would not shy away from intervening and turning around a prohibition decision, which I think in itself is very valuable. I think the court has also essentially signaled that a 4-3, as you said, is not a per se prohibition. The Commission does need to work hard to prove that a 4-3 is a problematic type transaction. And in particular, in cases where the merger is not between two very close competitors or resulting in taking out a maverick from the market. So focus on the facts and build the case. I think that's the message to the Commission. And in turn, merging parties can look at that and say, well, we need to bear that in mind in terms of whether we can get our deal through or not. I think the third message is, Commission, if you are to rely on novel theories of harm, not the bog standard theories of harm, the burden of proof is so much higher. So you do need to make sure that you have built up your case properly when relying on such theories. And I think that's got an interesting application, in particular in our world where there's a lot talked about innovation, impact on M&A, on innovation and R&D, digital markets and the like, where the economy is changing, the application of the rules has to evolve as well. It can't stay still. The last point I'd make was on the substantial lessening of competition. I think the message there is to say, yes, we moved away years ago from not having just purely a dominance type rule in merger control. It's not a question of, are you going to become dominant or not? There was an introduction of the SIEC test. I think the message there is to say, well, that is not a lower burden of proof commission. You do still need to go and build your case and prove that there is substantial, or there's likely to be substantial impediment to effective competition, as you would have done in a dominance case. So the threshold is not dropped. Work hard on building your case before reaching a prohibition decision. And with that, maybe I'll pause to get the debate going.
Thank you so much, Rafik. It's always a pleasure to listen to you. And taking one of your statements there on the theories of harm and the need that the authorities, that the parties would expect the authorities to be more cautious in proceeding with economic assessment. Cristina, I would love to hear your views on the rationale or the reasonableness of where the court decided to overrule the European Commission decision, and also what are your views as regards the role of the economists nowadays in this type of cases?
Thank you, Christian, and thank you so much for the invitation. It's a pleasure to be part of this panel and to discuss this particular topic, which indeed, as Rafik has indicated, and as you have said in your introduction, has created considerable debate in Europe, and frankly, more than debate. This has been a situation in which positions have been quite upended by these judgments in Europe. It's been seen, frankly, as a big slap in the face of the Commission, and notwithstanding the Commission saying nothing changes here, we will defend very strongly in court, we will continue to do what we've always done, our standards stand firm. There is no question that it is already, in my mind, affecting the way in which they go about, to some extent, taking decisions. There's significant, already chilling effect on enforcement, just because it is also coming straight on the back of the Apple tax case, where the Commission also lost in court. Losing in court is a big shock to the system, and therefore it does make the institution sort of take a step back, even though in public they are, of course, continuing to say we will continue to apply this. And in fact, it is having also a big effect beyond the Commission, because at the same time, corporate entities are all over just trying to come up with new mergers. I feel there are lots of inquiries and people saying, well, deals that were dead ducks, they should never even come out of the boardroom. People coming out and saying, can I have my merger now? Is the Commission now going to just kind of let me have it? And this is not just in telecoms, but it is in all sorts of fields. So it has, I think, chilled the Commission to some extent. We see it in Google Fitbit. This is a case that should obviously be blocked, but the Commission is very reluctant to do so because it is worried about losing in court. Make no mistake, there is no other reason why they don't want to block it. And the second point is, of course, on the side of corporates and advisors, there is a big effect in emboldening them. Now, I agree with Rafik that, of course, the court is saying, we cannot assume that every 4 to 3 is problematic and you Commission need to work quite hard. But we also need to understand that there is context to these things. There's context to this particular case. This was a telecoms case that came on the back of a series of 4 to 3 in Europe, starting from Austria and even before in Europe, in which we have seen consolidations of 4 to 3. And there was a concern that these consolidations, particularly where the remedies have been a little bit on the light side, some sort of behavioral MVNO kind of thing, had not actually remedied the problem. So there is, or there was, and there is even today, a strong view that notwithstanding the fact that you cannot assume that every 4 to 3 should be blocked, Well, look, 4 to 3 are problematic. They are concentrating markets in ways that are likely to lead to price effects. We know this. It isn't as if it is an eccentric position, right? We know that these cases will tend to bring prices up. And then the question is by how much? I agree with that, but there is no question that the direction of travel cannot be, oh, I scratch my head, will prices go up here? Maybe not. Of course they will. The question is by how much? And if there are offsetting efficiencies that are not laughable, ultimately. So, at the time of the case, the policy direction was clear and I think justified personally in that we know not only there are price effects, but also investment effects of these kind of mergers are not benign. There is no piece of evidence out there that says credibly that when you concentrate markets, telco markets, you're going to see more investment. This is false. And so the concern in its heart is well justified from an economic perspective. The question is then what you need to do to do the case. And so what the Commission did was apply the kind of techniques, the kind of approach that they had applied in a series of previous cases, and nothing particularly inventive. There wasn't a really novel theory of harm here. They'd done the kind of things they'd done previously in other cases. And the court says, look, I really don't find this convincing. And they insist on very strongly what they articulate as the what needs to be shown. They say that in order to show a problem, and they insist very much on this concept, it's not just enough to show that there is a law, that the parties exercise a competitive constraint on each other. It must be a particularly important competitive constraint. And it's not enough to say there is some reduction of competition. There must be specific reduction of competitive pressure across the others. And then they go on to say, and the quantitative analysis that the Commission did doesn't satisfy us, doesn't prove these 2 points. In fact, they should have considered efficiencies directly into the analysis, which we didn't. Which they didn't. They should not just consider efficiencies at the back end as an offset to the price effect. The current approach in Europe is you do all of this price thing, and then at the end you have a section that says, well, there are these efficiencies, and the Commission usually ignores them. No, the court says you need to include them into the assessment because we know that mergers lead to some cost reductions, right? Any merger leads to some cost reductions, so you need to include them. So in this sense, the court is not saying crazy things, and it's saying reasonable things. But, in practice, what does it mean that we need to show that there's an elimination of a particularly important competitive constraints? Well, as an economist, I know, and we know that there are effects on prices, even if you're not the closest competitor, right? I mean, in an oligopoly, there can be material price effects, even if you're not the closest. Now, okay, how do you actually measure that effect? Well, I mean, we need to do some quantitative analysis. I agree, these quantitative analyses are not particularly dispositive in and of itself, because think about it, they are put together with a margin and a diversion ratio. These things are very fragile. So you end up with, the price increase will be 2.7 or 3.5 or maybe 2.72. This is false precision. These kind of tools that we have are incapable of really definitively telling us what the exact number is. And the court says, well, you should have told us what the benchmark was. Well, what this kind of analysis can tell you is that the price fills a pool. The price is going up. The question is it small or is it more sizable? Are we in the 20% range or the 10% range? More than that, we cannot do. But more broadly, I think that the reaction on the part of the economists has been, that's all very well, thank you very much, court, but you are effectively setting a pretty impossible standard for enforcement. And when I say the reaction of economists, of course, not those who worked on the case, but those who are outside and kind of commented on this, because it is a pretty difficult standard to achieve in some sense. And there is the broader issue that, we do worry about markets becoming more concentrated. We have presided in Europe, certainly, over the serial concentration of markets in chemicals, agrochemical, pharmaceutical, telecoms, consumer products. Markets have become increasingly concentrated over the last 20 years in ways that I do not think are benign. The evidence for efficiencies is not there. I don't think there is any evidence that consumers have benefited from it. And what we've done in enforcement is focusing as economists on these very narrow kind of questions about price effects without taking a step back and looking at the bigger picture. Is it good that markets are concentrating? Is there evidence that efficiencies are really important and we shouldn't forgo them? I, as an economist, haven't seen any, almost. I've done 200 deals in 25 years. I see very little that is beyond perfunctory when it comes to efficiency. So I think that we need to think and put things in context. Yes, the court is there slapping people around, rightly so, when they do something which is a bit sloppy. But I worry that this judgment is a chilling judgment on enforcement at a time when we don't need less enforcement, because markets are not going the right way and not in direction that benefits consumers. So I'll leave it there and we can continue later.
Thank you, Cristina. I'm sure that we'll have some views on your statement from Alexandre later on. But at this point, I would like to turn out to the US, to Maureen, and listen a little bit to your comments, Maureen, on how do you see the impacts of this decision in the US? And as we have discussed before in the preparation of the panel, how do you see in the US this rebuttable presumption for horizontal mergers? And you have also mentioned these acquisitions of incipient competitors in the market and the manner in which the US authorities are reviewing these transactions, and what are the standard of proof that the authorities are applying there with respect to this type of acquisitions.
Great. Well, thank you. And I'm delighted to be here joining this very interesting and august panel. So thank you for having me. So in the US system, mergers, challenges to mergers get reviewed in court very frequently. There's a lot of settlements, or sometimes, when I was the chairman, we brought a number of challenges, some where the deals got abandoned right away when we brought the challenge or shortly thereafter, and some that actually went through litigation and we won those challenges. So having this level of court scrutiny, I think, is probably more typical in the US. But when the antitrust agencies review an acquisition, a transaction in a market that has high concentration and market shares, they do get the benefit of something called the Philadelphia National Bank presumption. And that goes back to a 1963 case in the US Supreme Court that was actually written by Judge Posner when he was a law clerk. So he can, famous antitrust judge, kind of putting his stamp on antitrust law very early in his career. And then in the horizontal merger guidelines that have been adopted in the US, which aren't binding on courts, but the agencies use those to screen out deals, you can see that these market share presumptions continue. Now, the presumption doesn't give the agency, the trump card. It doesn't necessarily win. It's a rebuttable presumption. So the parties can come back and say, that's not an accurate reflection. There are efficiencies, or there's going to be entry, or things like that. And as economic tools have gotten more advanced, you see that the presumption in some ways has become less strong. Now, when I was at the commission, there was a lot of academic debate, particularly on the right, on whether we should get rid of the presumption, whether it didn't make sense anymore. And I'm actually not in favor of getting rid of the Philadelphia National Bank presumption, but I always saw it as just the beginning of the conversation, not the end of the conversation. So once the agencies had analyzed the mergers and decided that on balance, they were going to be anti-competitive, then going into court, the presumption was a useful tool. But what it's really supposed to be doing is looking at what is the likely effect down the road in a particular market. So what you see is that there have been challenges about, well, is that market the right market? Is that market being undermined by innovative changes, by businesses going away, new businesses coming up? And that's one of the areas in which we've seen both in both directions, where the presumption may not be getting things quite right. So in this kind of inherently predictive exercise, are we able to say that the picture that we're seeing now is the picture where competition is going? So an example I like to use is when the FTC was doing a deep dive into the Hollywood video Blockbuster merger. So that was a video store, so where you go in and get your video cassette, and it looked like a high market share transaction, but and the parties eventually abandoned it when the FTC kind of did a deeper dive into it. But I felt our analysis completely missed, or didn't completely miss it, but didn't take into account sufficiently the rise of streaming video, right? So it looks a little laughable right now to be, concerned that, two dying video rental chains were trying to band together when the tidal wave of streaming video was coming. But then on the other hand, one of the things that we need to pay attention to is when there is a new competitor coming up in the marketplace. So that kind of brings me to the next issue of nascent competitors. Does the current market share of that nascent competitor reflect what is competitive impact going to be down the road? So the agencies have been paying attention to this. When I was the chair, we brought a challenge called CDK Automate, where we said that this kind of smaller player, current market share it was a concentrated market. There were two big players and then a bunch of fringe players. And we brought a challenge saying, well, this particular small player was really poised to start to take over a bigger market share. And you could see it in, the discussions about it. We brought the challenge and the parties abandoned the deal. And you've seen other nascent competitor challenges, the Illumina PacBio case, the Harry Schicks case. So the agencies are paying attention to that. But again, it's always this predictive exercise. So the other question is, are the agencies getting notice, right? Do they know these things are happening? And so the deals that I've talked about, CDK Automate, Harry Schicks, these were all actually met the merger reporting thresholds in the US. So the agencies are getting notice of them for the most part. And that makes sense, right? Because if you think about the fact that if a well-entrenched player is concerned about an upstart that may be going to be able to cut into its, possibly supra competitive margins, the valuation for that startup is probably going to cross the threshold, and I think that's one of the things that we've seen. But certainly the agency, at least the Federal Trade Commission, has a study right now looking back at 10 years of non-reportable transactions for, so it's Google, Amazon, Facebook, Apple, and Microsoft. And I think they're looking at whether the thresholds are, sufficient. Congress sets the monetary threshold, but I think that's one of the questions that they want to get a little more data on to see if they are getting a sufficient amount of information about these kinds of smaller deals. So I'll stop there, but that's the state of play in the U.S., at least as of today.
Thank you, Maureen. I think that we have a similar move in Brazil as regards the small acquisitions, and it also raised the same type of concern, but on a different way, on the standard of proof beyond market shares. Because here in this type of transactions, you have maybe big players acquiring small shares by acquiring these startups or these unicorns. But still, the market share analysis, the resulting market share analysis, would not be sufficient to evaluate the impacts of the transactions in the market, right? So I think that the standard of proof in these cases should also be reviewed. And I think that this is what the authorities are doing in the US and in Brazil also in certain investigations. But now, Alexandre, we would like to listen from you on how you see all these discussions on the review of the antitrust authorities' decisions. We know that in Brazil we have this two-level review process in which the superintendent's opinions can and recently are being reviewed by the tribunal in a more often basis. And how do you see this? And how do you see how the effects of the possibility of having the superintendent's opinions or decisions being reviewed by the tribunal in terms of quality of the grounds of the decision? And also, how do you see the current situation in Brazil where the tribunal decision can be challenged by the courts, but in practical terms, this will not happen, and this does not happen in merger case because it's not effective. And how do you see the effects of this situation in the quality or in the efforts that the tribunal devotes in building its decision, considering that hardly it will be challenged by a court decision?
So good morning, everyone. Chris, thank you very much. I know that you allow me to speak in Portuguese, and I will switch to Portuguese in a few minutes. I just want to say hi to everybody and say that it's a pleasure to see everyone here, Maureen, Christina, Rafiki. I can remember when I was in FTC, visiting FTC, and Maureen was there. She welcomed very well. So I would like to understand more about FTC. This was like some time ago, so thank you very much, Maureen. I miss Christina Cafara a lot. She's a very nice person, so we have some opportunity to have some fun together abroad. I wish you were here. Actually, you won us a visit here in Brazil, and Rafiki also will have been in touch for in the other events. I think that you also worked in Susana and Fibria case, I think. So it's very lawyer, and thank you very much. So, and I want to thank Ibraki to once having this event. Unfortunately, it's not on live, so personally, so we could meet everybody and have some fun together after the business as well. So, but I will now switch to Portuguese. I know that there is translators, so I try to speak a little bit slow as well in order to everybody to be easy. Became easier the work of the translators. So. Bom, então eu vou falar em português em homenagem também às mais de 200 pessoas que estão assistindo a gente, pelo fato do evento ser no Brasil e ter tradução, me parece adequado. Bom, essa discussão é uma discussão que não é nova. É uma discussão, padrão de prova, a gente discute isso em conduta, discute isso em AC, e algumas coisas são muito importantes quando você está fazendo uma análise de um ato de concentração. A primeira delas é sempre dar muita transparência, previsibilidade e segurança jurídica para o mercado. Essa é uma das principais missões que a autoridade antitrust tem, dentro da sua missão institucional, que é cuidar da concorrência. Ela tem que ser transparente, ela tem que gerar estabilidade. E quando você discute padrão de prova e mostra como é a forma de análise, ou pelo menos dá algumas diretrizes da análise de como você fará em um ato de concentração, isso traz estabilidades para as partes. Por isso, a importância de um guia robusto e que a instituição realmente siga o guia que foi estabelecido. E existe uma dicotomia muito grande, né? O quanto de ferramentas econômicas a gente vai utilizar e o quanto de credibilidade a gente vai dar para essas ferramentas econômicas e qual é a análise qualitativa que a gente vai fazer. Essa dicotomia, esse paradoxo não pode ser nem lá nem cá. Eu acho que tem que ser um meio termo e é case by case. Então, a Cristina falou uma coisa muito interessante. Muitas vezes as nossas ferramentas você não tem as ferramentas econômicas, você não tem a precisão de como você trataria um mercado ou se aquela variável realmente é relevante para o resultado que você quer chegar. Por isso, uma só variável não explica o caso. O que explica, sim, são diversos testes econômicos e sempre a autoridade entendendo o limite deles associado à avaliação qualitativa. Isso é muito importante, mesmo porque a gente tem que focar muito na qualidade dos dados que a gente está recebendo. Veja, a autoridade antitrust, em regra, é generalista em todos os mercados e especialista em concorrência, portanto, existe uma assimetria de informação muito grande. Então, para quem está do lado de dentro do balcão, investigando o caso, é muito importante que as informações cheguem, quanto mais precisas, melhor é para você mitigar uma possível decisão errada e melhor avaliar as variáveis que você vai trabalhar. Então, isso é muito importante. Então, concentrar na qualidade da investigação para diminuir a assimetria de informação e, a partir daí, poder valorar as variáveis e os testes que lhe darão mais precisão para tomar uma decisão é extremamente importante para a autoridade antitrust. Então, o CAD, e aí a Maureen lembrou lá a PNB Presumption, lá de 1963, que é um caso interessante, a gente usa, e até vou sugerir, tem um livro da Law Journal, se não me engano, de uns 3 anos atrás, que fez uma publicação inteira sobre essa PNB Presumption, discutindo se ela ainda permanecia ou não. Inclusive tem uma entrevista muito interessante, se não me engano, do Judge do Posner, tratando dessa questão, e aí ele concorda com o que a Cafara falou sobre as questões de eficiência. E tem uma pergunta de alguém na plateia, se não me engano, não sei se foi do Joshua Wright, fez uma pergunta dizendo, olha, como é que ficam as questões de eficiência? E ele é muito claro em dizer, é muito difícil você ver uma operação ser aprovada só com eficiências. E eu não tenho conhecimento disso e é muito raro. E quero ver como isso ainda pode ser passado para o consumidor. Então, me prove isso, me demonstre isso. Isso é muito interessante. Eu, nos 5 anos que estou no CAD, né, já um pouco mais de 5 anos, pouquíssimas ou nenhuma praticamente, acho que nenhuma operação de ato de concentração a gente viu ser aprovada no CAD por conta de eficiências, demonstrando, sob o ponto de vista dos efeitos, que as eficiências superam os prejuízos. Em regra, o ato de concentração no CAD, 99,9% dos atos de concentração no CAD, acabam no 3º passo da análise. Depois de definir mercado relevante, analisar a concentração na probabilidade de exercício de poder de mercado. A gente analisa ali. A hora que a coisa chega na eficiência, a eficiência pode ser um complemento para, dentro de um cenário conservador utilizado pelo CAD, nos dar mais conforto para uma tomada de decisão. Mas é muito raro isso acontecer. Então, é muito importante que, e aí é evidente que a necessidade de provar é da administração, o ônus da prova é da autoridade. Então, a regra é que atos de concentração são fatos da vida natural de um mercado, portanto, isso tem a todo momento. A gente tem, em média, 450 atos de concentração sendo analisados pelo CAD e pouquíssimos são atos complexos que sobem para o tribunal. A maioria são aprovados sem nenhuma restrição lá pela superintendência, ou até mesmo quando sobe para o tribunal é reanalisado e grande parte aprovado sem nenhuma restrição. Então é importante notar que a intervenção do Estado no momento de bloquear uma operação, ela tem que ser muito cuidadosa, tem que ser muito precisa, e muito precisa para os dois lados, para você não criar nem falso positivo, falso negativo. Isso é muito importante, para você não intervir de maneira errada na economia e com a desculpa de consertar um problema, acabar criando outro maior e passar um sinal trocado para o mercado. Por outro lado, a gente tem que cumprir a nossa missão institucional, que é proteger a concorrência, proteger os consumidores, não deixar que a qualidade dos produtos caiam, que diminua a oferta, que aumente os preços. E por isso, na investigação, a gente faz diversos cenários. Então, sob o ponto de vista prático, quando a gente está analisando um ato de concentração e a gente tem dúvidas de quais os cenários utilizar, a gente faz vários cenários, utiliza várias ferramentas com várias possibilidades e sempre adota aquela mais conservadora na defesa da concorrência. E aí, a partir daí, a gente tem pelo menos uma maior certeza de que aquela fusão não causará nenhum prejuízo, ou pelo menos bastante mitigada a possibilidade de prejuízo, que é o passo 3 da análise do ato de concentração, é a probabilidade de exercício de poder de mercado. E aí, para além disso, a gente ainda tem um sistema de freios e contrapesos dentro do CAD, sistema um pouco diferente, muito parecido com o que o Rafik disse, na Europa, é um sistema muito administrativo. Então, a gente tem a superintendência fazendo a investigação e emitindo uma decisão ao final. Essa decisão, quando ela é para aprovação sem restrição, ela pode ser monocrática ali e ali ficar, mas quando ela quando a gente entende que tem algum tipo de problema, a gente faz a impugnação da operação, já com uma proposta de remédio ou para reprovação da operação, aí o tribunal vai rever a operação. Para além disso, o caso também sobe na existência de terceiros interessados que apresentam recurso, ou então, quando o tribunal resolve avocar uma das operações que foram analisadas pela superintendência. Isso é muito interessante porque o sistema de freios e contrapesos, o tribunal, como sendo um colegiado e tendo 7 cabeças ali pensando, tem a oportunidade de revisitar o caso e muitas vezes consertar uma falha ou outra cometida pela superintendência ou até mesmo mudar o posicionamento ou fazer novas diligências a fim de ampliar a investigação. E aí, respondendo a sua pergunta, Cris, o nosso sistema não é um sistema de que quando a gente quer bloquear uma operação, a gente tem que desafiá-la junto ao judiciário. Ao contrário, o sistema brasileiro a decisão do CAD, sob o ponto de vista administrativo, é a última instância, a decisão do tribunal. E essa decisão pode ser desafiada no judiciário quando as partes levam ao judiciário. E aí é uma ação de anulação de ato administrativo em que existe uma discussão muito grande no Brasil sobre a possibilidade do judiciário intervir no ato administrativo. E, portanto, política pública concorrencial, ou seja, se aquela operação exerce ou não uma pressão competitiva, pode ou não ser aprovada, se não houver nenhum problema formal de due process, nada nesse sentido, se trata de mérito administrativo e, portanto, o judiciário conforme jurisprudência, inclusive decisão do STF muito recente, não tem a competência ou legitimidade para tratar de mérito de ato administrativo, porque se trata de política pública. Bom, eu vou ficar por aqui, deixar para o debate, acho que eu já até falei demais, eu não sei quanto tempo eu tinha, Cris, mas eu acabei esticando um pouquinho, eu vou ficar por aqui.
Imagina, Alexandre, muito obrigada. Eu só queria fazer um comentário para o público, que o canal de perguntas e respostas e está aberto. Então, se vocês quiserem enviar perguntas pelo canal, a gente endereça aqui para os palestrantes, tá? Alexandre, me desculpa, só que eu vou continuar no inglês, mas a gente volta no português daqui a pouquinho. Continuing here and having listened to you, Alexandre, it comes to me, and this is something that we the panelists have discussed about the deal strategy, or the strategy that the companies should adopt, taking into consideration the manner in which the authorities review the cases. So, of course, that, as you mentioned, it's very important to have clear guidance from the authorities on how transactions will be reviewed, what are the standards that the authorities will use, the transparency that CADE always has demonstrated to the parties. This is all very important. But when you have a decision as the one that we saw in Europe, does this affect, Rafik, the way in which the parties and the lawyers and economists should establish strategy to file a case, or to construe a case to be filed with the authorities? Is there a fear, or a fear from of having the deal challenged on the authority side, or an additional confidence on the party side that the construction of the strategy would be taken very carefully by the antitrust authorities, because of the fact that a decision from the antitrust authorities could be challenged by the courts. And again, we all know, and the statistics demonstrate, that it's not so common to have antitrust authorities' decision, or the European Commission decision, being challenged by the courts. But the fact is that what we have seen, and we have recently seen, a decision being overruled. So how this has impacted the construction of the strategy in complex cases, if at all, has changed?
Yeah, good question. I think, again, I'll start with a process point, which is how long does it take to get through the appeal process in Europe? So if the European Commission has blocked a decision, on a standard process, it's taking you 2 to 3 years to go through the courts in Luxembourg and turn the Commission's decision round. In an expedited process, it could be a bit quicker, but again, it's a very long period of time. So I would say, yes, we can talk about the theory as antitrust lawyers, but in the real world, how many deals do you actually have the luxury of that much time to reach a final determination on whether the deal's going to happen or not? And if you break it down into, look at a public M&A deal. Public M&A deal would not support this kind of timetable. So you'd have to do some, what at least we call in Europe, a sort of a preconditional type offer, where you go and sort out your conditions, you meet them, and then you launch your offer. But I can't see a public offer being open for 3, 4, 5 years because the markets would have changed, and it's just not going to happen. In a private M&A deal, the lots, we're in a world where auctions prevail. So if an auction's prevailing, what are the chances of you ending up in a world where you can't afford that much time to get to the bottom of the case? So the application, I think, or the lessons coming out of this case, firstly, are quite narrow in terms of, yes, 4 to 3 years, don't assume that it's problematic. But again, there's a lot of focus in there on closeness of competition or mavericks. It's not any 4 to 3, right? So even if you assume that your case fell smack in the middle of these facts and you could benefit from this particular case, you'd need to have the commercial reality of the deal allowing you to potentially benefit from this kind of outcome, to be able to say, okay, this is the route I'm going to follow. So there's a lot of commercial negotiations that you're going to have to go through as parties to say, we're willing to hang on for 2, 3, or 4 years. That is in the real world, in the commercial world, that's a very long period of time for this to materialize and you being able to benefit from it, as it were. Now, is there, putting that aside, is there a general sense from the Commission to say, oh, we need to be cautious here because we've been embarrassed twice over the last couple of years? Yes, but I wouldn't overstate that at the end of the day, because, I mean, the facts, Christina was explaining this earlier, the facts are specific, right? And they're not, you don't just, the facts are not carbon copy across several cases. So it's always possible to distinguish one case from the next. So I won't overstate that too much, but yes, it has had some sort of an effect. But I think it's commercial reality which is going to prevail ultimately.
Yeah, I think that it's more or less the same approach that we have here, right, Alexandre, regardless this decision from the courts in which could be discussed in terms of the merits, meaning that how much the merits of an administrative decision could be challenged in court, but the fact is that it takes too long. In any case, it would take too long. So it's something that must be taken into consideration. And I think in Europe, while the decision is being challenged, you cannot implement the deal, right?
Correct. You can't implement the deal. Another point is that as part of the notification, when you go to the Commission, you're submitting your sale and purchase agreement. So the sale and purchase agreement will have a clause in there to say we've got a long stop date, we've got an obligation to do X, Y, and Z to meet the conditions. That's one of the first things that any authority is going to read. They're going to see what the timeline is, what the tolerance level is of the parties to the deal. So, and on a public deal, obviously that's going to be all public, but that is there in black and white in terms of what the tolerance level is and when parties can actually walk away. But that's also giving some sort of visibility, it's a different topic, of what the parties would be prepared to do to get the clearance. I mean, if you look at the statistics, you'll find that the Europeans will tell you that over 90% of cases coming out of the European Commission are unconditional clearances. And I'd say, yes, correct. But if you take away the simplified cases, so the real no-brainers, box-ticking type exercises that Christina doesn't get involved in, it's 26% result in remedies. So 26% is quite a significant percentage.
Certainly, Hafik. Certainly. And Maureen, I would like to listen from you. What are your comments on this strategy? You described a little bit how is the system in the US. And I think that in the US, the decisions are taking a little faster, especially because they are usually challenged in court. So we would like to listen from you, your views on this topic. And also, if you could bring us also your views on how the antitrust review process could or would change with the new administration in the US. I think this would be something that everyone would like to listen.
Sure, thank you. Well, Rafik brought up excellent points, which is the longer the review takes, the harder it is to keep the deal together, right? There's lots of different factors, uncertainty, valuations, and that certainly can undermine the deal for reasons completely unrelated to the competitive effects. Now, in the U.S. and
this is the reason why you mentioned, sorry, Maureen, to interrupt you, that you said that whenever the authorities challenge a decision, in many situations, the parties themselves, they drop the case. They give up, right?
Yes. Well, yes, because they realize it'll be a kind of a longer slog. And so that's right. So, look, a lot of deals, most of the deals that get notified get cleared, right? So we have a notification threshold that is already serving up notice of a lot of non-problematic transactions, and they get through quickly. Then there are the ones where there's a second request and the agencies look more deeply, and those more frequently, but not always, come to either a settlement, right, where there's a problem and you say, but it's fixable if you do these things, or a challenge that gets abandoned. But then for the cases that go to court, the preliminary, so the agencies need to get for an unconsummated merger, because as you all know, under the Hart-Scott-Rodino Act, the parties can't close, right, if the agencies find a problem, and then go into court and try to get a preliminary injunction. And that happens a lot more quickly. So that's more accelerated process. It's not quick, but it's still an accelerated process due to the the difficulty of holding the deal together. And then typically, if the agencies do get a preliminary injunction, the parties then abandon at that point, though there is always theoretically the possibility of an appeal of that. So just to give you some examples, so when I was the chair, we brought a challenge to the Williamson-Drew merger that we litigated and won in court, the Tronox Crystal deal, which had a funny kind of, because Europe hadn't approved it yet, so they couldn't close. So we challenged it administratively and had an administrative trial. And then once Europe had done what it was going to do with the deal, and we won in federal court to get a preliminary injunction. And so the agencies do, proceed to court where they need to, and they've actually been pretty successful for the most part in their challenges. And so I think one of the issues, though, is for the agencies is not fear of not winning in court, but the resource constraints. It's very expensive to litigate a case, and the budgets are not that large. And actually, on a couple of cases while I was at the commission, we had lost at the district court level in 2 hospital merger challenges, important ones, one in Chicago, one in New Jersey. And it seemed pretty concerning, but then on the courts of appeal, they overturned those and actually did grant the injunctions to the mergers. So the question that you raised is what's going to happen in a new administration. There's lots of discussions about tougher enforcement, more enforcement, things like that. And it's interesting because when you kind of point back to a record, like, well, we brought this challenge, we brought that challenge, we won this, we won that, people tend to say, oh, you only pick the easy cases. And I like to say, well, if you mean the cases where consumer harm was very evident, then yes. Isn't that what we should be doing? But not all of them were easy cases. But I think there will be now this, with this intense focus, deals that maybe previously were kind of marginal, whether they could be settled or the settlement, the parties wouldn't agree to everything the government wanted. I think those might tip more into litigation. And so there may be more litigated merger challenges, but I think one of the issues there is, again, the resource issue. Look, when I was the chair, we had more cases in active litigation than, had been the case for the past 20 years. We were fortunate that because it was just me and Terrell McSweeney, that we were actually able to use some of the money that would have been budgeted to support the other commissioner offices, which were vacant, to redirect those funds for experts. Now that the commission's fully staffed again, they don't have that flexibility. So I think that will be one of the, even if they want to take a more aggressive posture, just having the resources to litigate that. Then one of the other issues is that litigating borderline cases often has the risk of ending up worse off, right? Because if you bring a case where the court, well, not even just borderline cases, if you start litigating, very weak cases, you can end up worse off, that you end up with precedent from the courts that makes it much harder to bring the next case. And while I'm not saying that the AT&T Time Warner case was a borderline case, but when you look at the decision of the DC Circuit in that case, it actually, I think, makes the bar a little higher for the next vertical merger challenge. So that's always one of the risks. And people sometimes say, well, just go ahead and bring these cases, and it's like a, shoot the moon, let's bring a whole lot of cases, and then if we lose, then it'll be clear, that Congress needs to change something. Well, one of the problems there is there's only so many resources. So if you're doing that, it means you're not bringing other cases where the consumer harm may be more evident. And you risk getting, worse case law that makes other good challenges more difficult. And is Congress really going to change the antitrust laws? At this point, I think that is, very unclear. When you look at, for example, the House Judiciary staff report, right? So that was a staff report that recommended some changes for mergers, changes in presumptions, some prohibitions. The idea that will necessarily be enacted into law in this current, the new administration, I think is not a foregone conclusion. The Democrats lost seats in the House, right? So they have a smaller contingent, and it looks thus far, the betting is that the Republicans will hold the Senate. So the idea that you're going to get some sweeping antitrust reforms through, I think, seems less likely. So I think that's one of the challenges is even in a new administration. Yes, you can challenge more deals, but it comes at the cost of resources, risk of loss in court, being damaging down the road. But we'll see. I think for deals, like for counseling, the borderline deals are going to be challenged more frequently. That's my prediction for the new administration.
Thank you, Maureen. José Carlos acabou de me dizer, pessoal, que participa, todos a audiência, se vocês quiserem mandar perguntas, mandem pelo Q&A, e aí eu abro aqui e endereço aos participantes, só reforçando o aviso. So, turning to...
You're on mute, Christian.
Sorry. Cristina, I would like to listen from you on case strategy, and I have a question for you, which is about, again, going back to the role of economists in the preparation of a filing. If you believe that this statement from the courts in Europe that assumptions or presumptions of harm should not be the basis for decision, do you believe that this is something that will prevail and will impact or influence a case strategy? And what will be the role of the economist if this is something that will, in fact, be the basis or be the guidance for the Commission to review antitrust cases?
I don't quite know how to answer that. And I can tell you, to relief of many people, that economists don't get very involved in the strategizing about how to bring a case. We tend to just be wheeled in as useful when we have to do some work that supports the case, right? And so what I want to say probably is... Well,
this is not exactly the truth in Brazil. I think that we all build the cases with the economists. Sometimes it's very good, sometimes it's very complicated.
Yeah, no, I get that. But, I have a view about this, which is probably a long-term picture. You're asking me to opine on something. What should we do now? I don't know. My view about how the role of economics has evolved is perhaps somewhat controversial, but I'll briefly state it anyway. I mean, I've been in this game for long enough, for 25 years, and so I think I fought two big intellectual arguments. One, all that time ago, to bring more economics into cases, to do more economics, use more economics tools, because at the time in which I came into this, there was a lot of presumptions. We used to laugh at the Germans and say, these silly Germans, look at their presumptions. They don't know how to do effects cases. That's incredible. We need to do case-by-case economic analysis because that's really the way. So that has really come to pass. We won that argument as economists in Europe, and we are used very, very very extensively in cases. I think at the same time, and this is the second, swing of the pendulum, that economists have actually narrowed themselves into doing something very, very specific, some price analysis. Why? Because we have the data to do that. So we do this price analysis, price effects, and the price is a bit higher, a bit lower, and you get into this fairly mechanistic, fairly established role that economists these days play. Economists have become economic advocates. Frankly, economists come in, they're wheeled in, that's what I say. They help the transaction, they have to say something helpful. Say that the price effect isn't too high. Say that the price effect is really a little bit. Not really worried. No, I can change this, I can change that, and make it look small. But the reality is that the creativity and the understanding for what is really going on is not coming from economists these days. And that is a concern that I have about where economists are going, where the profession is going. We need to ask real questions. Are we doing the right thing? When we're looking at these mergers in this very narrow way, we are fixing a little bit of a price effect with a gerrymander remedy in this very, very narrow piece, and we let the merger go through and we let the market consolidate. So we have a deal in which we put together two pharma companies. There is a problem in two cancer drugs. We sell the overlap to Nestle, who makes cat litter. So exactly what are we doing? I worry about the role of economists having been these days confined in doing mechanistic price analysis. The creativity and the understanding about competitive effects is not coming from economists. It's coming actually more from the agencies. It is the agencies that are reawakening the potential competition thing. The CMA in the UK has been a pioneer to think about potential competition, killer acquisition in this space and in other spaces. This ain't coming from practicing economists in cases. Practicing economists are always saying nothing there, nothing to see, no, price effect small, nothing else. And then you have the innovation thing. Innovation concerns in places like agri-pharma. There's been a big battle in Europe about the role of these concerns. This hasn't come from economists in practicing economists. Yes, academics, but practicing economists in cases have all said, no, there's no innovation, just doesn't get worse if you consolidate, maybe even to monopoly. It's okay, we're paid. So I think I have a concern about what economists are often saying. That isn't to say that economics as a discipline is not useful. I don't want to see us going back to the days in which we had just presumptions. And economics has been useful. We know that, for example, in a bidding market, you cannot do just stupid market shares because they don't tell you anything. We know that not all vertical mergers are bad, and you need to look at that case by case. But I think economics has narrowed itself down to exceptionalism. Every case is different, and you can't say anything unless you do these really narrow price effects, and then maybe you can argue they're small and then try and get it through with a very gerrymandered little remedy. I think that it's a bit of a problem for where economists are, so I don't know where this is going. And going back to your question, what will be the role? Well, we'll continue to do, economists will continue to do what they're doing. I think there is a concern that we're not sufficiently big picture. We're not understanding where the political economy is going as citizens, not just trying to defend this next little merger. So I'll leave it there.
Thank you, Cristina. Alexandre, eu gostaria de te ouvir agora nos final remarks sobre como que você, como autoridade, viu essa decisão das Cortes Europeias, onde foi defendido que a redução da pressão competitiva, não necessariamente pela eliminação de um player, né, dos 4 para 3, não necessariamente deveria ser entendida como uma presunção de um problema concorrencial. Isso é uma pergunta. E como o EC, considerando a todas as interações que o CAD tem, tanto com as autoridades americanas como com as autoridades europeias, como isso teria algum impacto nas discussões internas do CAD sobre padrões de prova, ônus da prova, enfim, se isso de alguma forma gerou algum tipo de atenção para vocês, essa é uma pergunta. A segunda pergunta é, você enxerga hoje o tribunal um pouco mais ativo nesse papel de revisão das decisões da superintendência, ou é uma questão conjuntural, os casos recentes de avocação, assim, existe uma preocupação maior da superintendência em relação a essa possível tendência, se é que ela existe? Então, essas duas vertentes que a gente gostaria de te ouvir.
Vamos lá, Cris. Em relação à decisão europeia, eu tendo a concordar muito com o que a Cristina Cafaro falou. que, evidentemente, que todos sabem disso, quando você reduz um player, você mitiga a concorrência. A discussão é saber o quanto você vai mitigar a concorrência. Não necessariamente o que é grande é ruim, e também não necessariamente você reduzir de 4 para 3, você está realmente gerando problema para a concorrência. Até sim, e por isso tem essas presunções, é isso que a gente imagina. A gente acha que se reduzir os players, especialmente de 3 para 4, de 3 para 2, de 5 para 4, especialmente se for rivais efetivos, é lógico que a preocupação concorrencial aumenta com possível aumento de preço. Mas essa presunção não é uma presunção absoluta, é uma presunção relativa. A gente precisa analisar isso dentro do contexto do caso. Como é que aquelas empresas se posicionam no mercado, que tipo de mercado que é, se esse mercado tem barreira à entrada, não tem, se mesmo sobrando 3 existe uma rivalidade efetiva entre aquelas 3 empresas, se existe, se é um mercado de 2 lados, né, de que maneira ele consegue realmente abusar da posição dominante que está criando. Então, assim, é uma análise de caso por caso, uma análise específica. Eu acho que a Corte Europeia deu um recado, disse o seguinte: olha, cuidado com as presunções, você tem que analisar de uma maneira específica cada um dos casos, mas isso não quer dizer que a gente tem que simplesmente esquecer de tudo que a gente vinha fazendo e dizer o seguinte: olha, mudando de 4 para 3, a gente tem um problema concorrencial. Não, está dizendo a gente continua dizendo que pode ter um problema concorrencial, mas isso vai ser analisado dentro de um contexto específico do caso. Então, e como é que o CAD, como é que isso afeta o CAD? Como é que isso afeta, na verdade, os próximos casos do CAD ou das outras autoridades? As autoridades antitrust ao redor do mundo, elas vivem de melhores práticas e de cooperação internacional. A gente tem uma excelente cooperação internacional com a Europa, com os Estados Unidos e com todos. Isso faz com que a gente troque experiências e troque informações. O que a Corte Europeia acabou de dizer é o que o CAD vem fazendo há muito tempo, na verdade. Se você pegar diversas decisões e atos de concentração que foram analisados pelo CAD, até mudando em determinados mercados de 4 para 3, o CAD diz, sob o ponto de vista de efeitos unilateral, a gente entende que sai pela rivalidade, ou não tem barreira à entrada. E aí vem, evidentemente, uma preocupação de poder coordenado. Isso nos preocupa bastante, mas se você pegar a história do CAD, são raríssimas também as operações bloqueadas, única e exclusivamente com análise de poder coordenado. Você vai ter uma ou outra, e essa análise também de poder coordenado não é feita de maneira isolada, ela é feita no contexto de uma análise econômica, mas também uma análise qualitativa do passado do mercado para saber até a probabilidade que esses caras têm de fazer algum tipo de colusão. Então, o caso faz com que a gente reestude e reanalise os nossos padrões de prova, o que a gente tem feito. Óbvio, a gente está atento para tudo isso, mas isso é um negócio que vem de agora. A gente já vem fazendo isso há muito tempo e com uma evolução constante, tentando cada vez mais melhorar os nossos instrumentos, dar uma resposta mais rápida e tentando sempre errar menos. Lembrando que é sempre case by case, mas existem presunções, e as presunções são importantes. Eu vou lhe dar uma presunção que acho que é a presunção que mais funciona no CAD. Nós temos aí, na nossa lei, essa presunção é legal, que posição dominante para o CAD é quem consegue unilateral coordenadamente influenciar as condições de mercado ou quem tem objetivamente mais de 20% de poder de mercado. Tanto é que um dos aspectos, o primeiro requisito para enquadrar em um fast track, num rito sumário, é você ter menos de 20% numa relação horizontal e menos de 30% numa relação vertical. Isso eu posso te dizer que são 95% de todos os casos do CAD. A gente demora uma média de 14 dias para fazer a análise da operação e publicar a decisão. Imagina se eu tivesse que fazer não um quick look, mas uma investigação completa em casos que eu já presumo que não vou ter problema concorrencial. Agora, veja, presunção para você aprovar uma operação é uma coisa, presunção para reprovar é mais complicado ainda, por isso que tem que ser case by case. Em relação à sua segunda pergunta, Cris, é aquilo que eu disse da primeira vez. A estrutura que foi montada ao CAD com relação a freios e contrapesos, a necessidade de revisão das decisões da superintendência é de extrema importância para o funcionamento do Sistema Brasileiro de Defesa da Concorrência. Não existe no CAD, por exemplo, olha, eu estou vendo que o tribunal está avocando os casos da superintendência, porque... Não, faz parte do sistema. E é importante que se faça. O que eu costumo dizer é que não dá para se brincar com o mercado. E brincar com o mercado, eu digo o seguinte, é importante que se avoque casos que realmente sejam importantes sob o ponto de vista de criar algum problema, de ter algum problema concorrencial ou uma falha grave na análise. Avocar caso para reestudá-lo, eu acho que isso pode ser um desserviço para o direito antitruste brasileiro, para a instituição CAD e para o mercado. Isso é o que penso. Por exemplo, eu vou avocar um caso, eu vou avocar e o fundamento da avocação é esse. Existe um sério problema concorrencial aqui, que inclusive pode mudar o vetor da decisão da superintendência. Então é importante que se avoque, é importante que se revise esse caso. Aí eu acho que é válido. Porque a gente tem, para além das paixões de cada um, a gente tem uma instituição para poder tocar. A gente tem, na verdade, aproximadamente 450 atos de concentração durante o ano, mais 350 casos de conduta, o que representa aí, sob o ponto de vista de valor em atos de concentração, mais ou menos 100 bilhões de reais por mês. Isso dá mais de 1 tri e 300, 1 tri e 200, o que é grande parte do PIB brasileiro. A gente não pode brincar com isso. E tempo para o mercado é dinheiro. Tempo para o mercado, você pode anular, fazer com que a pessoa desista da operação. Foi o que a Maureen disse. E aí, eu vou até dizer para o Rafik, quando o Rafik fala que ele demora só 3 anos lá para poder julgar um caso na Europa, eu fico com a inveja danada, viu, Rafik? Porque aqui, quando vai para a corte, é uns 16 anos. A gente tem caso de 16 anos aqui discutindo fusão, que o CAD reprovou em 2004. Então, veja como... É importante você dar previsibilidade, dar celeridade, e agora, celeridade não é celeridade a qualquer custo. A celeridade é uma celeridade consciente da decisão que está tomando, protegendo a concorrência. Portanto, toda vez que se avoca, e aí é importante tomar cuidado com isso, porque às vezes o CAD pode ser instrumentalizado para poder ganhar tempo nos casos e partir para uma negociação privada. A gente já viu isso em algumas situações. É importante que o CAD defenda a concorrência, erre o menos possível, seja o mais ágil possível e as decisões, tanto de superintendência como do tribunal, tenha a visão de olhar para a missão, tenha o interesse mesmo de olhar para a missão institucional final do CAD, que é resolver alguma coisa de útil para o mercado e para a sociedade, não apenas avocar caso para discutir teses que no fim do dia acaba se resolvendo de uma maneira mais rápida e da mesma forma.
Alexandre, só nessa linha, sempre houve uma interação muito grande, né, entre a superintendência e o tribunal, no sentido de que, em muitas ocasiões, casos mais complicados em discussão na superintendência já eram discutidos, de alguma maneira, com o tribunal. O que, de alguma maneira, melhorava esse sistema, no sentido do que você está dizendo, da questão da eficiência do órgão considerado como um todo. Isso mudou, de alguma forma, não? Não, Cris, não mudou. A interação
que se tem com a superintendência e com o tribunal sempre foi, nos últimos anos, desde que eu entrei no CAD, pelo menos, ela sempre foi excelente. Isso nunca mudou, à medida que vai mudando o conselho, eu tenho ficado lá durante uns anos, mas à medida que vai mudando o conselho, os membros do conselho, a interação com a superintendente, a superintendência e o tribunal sempre foi muito boa, e se depender de mim, evidentemente, sempre vai ser, porque o CAD não funciona se não houver uma excelente relação entre superintendência e tribunal. Isso faz com que a instituição dê segurança jurídica para o mercado. Mais uma vez, eu volto a repetir esse aspecto, porque isso é de fundamental importância para o papel que a gente desenvolve. Então, não mudou, a gente discute muitos dos casos, quase todos os casos, principalmente quando a gente faz uma declaração de complexidade, a gente sobe com o caso para o tribunal, os acordos são discutidos. É lógico que muitas vezes você pode ter algum problema de comunicação, um erro aqui por parte da superintendência, o tribunal também entende isso, né? Então, a relação é muito boa e hoje não é diferente, né? Foi muito boa e hoje não é diferente, continua sendo muito próximo um do outro, mas sempre com aquela Chinese wall, né? É importante que eles sejam independentes também, para que exista efetivamente esse freio e contrapeso, porque senão seria uma instituição só, tudo que a superintendência faz, o tribunal concorda, tudo que o tribunal pede, a superintendência faz. Não, é interessante que tenha realmente essas duas instituições completamente independentes, mas que se conversam, que se reúnam em determinado momento para, inclusive, discutir quais são os rumos da instituição que a gente quer para os próximos anos. Está no mudo, Cris.
Perdão. Vou fazer uma última pergunta, porque a gente já está no final, mas é uma pergunta do Fernando Furlan, Alexandre, para você, nesse sentido das avocações. Se a SG se sente de alguma forma desconfortável pelas avocações, eu acho que você endereçou um pouco isso, que eu, pelo que entendi, desde que ela seja fundamentada, ela é saudável, né? Acho que é esse o ponto que você nos colocou.
Eu não tenho nenhum desconforto em relação às avocações. Algumas inclusive, são importantes porque existe realmente uma discussão efetiva sobre um posicionamento concorrencial que a instituição tem que dar. E é muito melhor, nesses casos, que essa decisão seja tomada até pelo tribunal do que pela superintendência, porque dá mais robustez e cria uma jurisprudência mais forte. Eu não fico desconfortável, não sou contra, e ao contrário, eu acho que esse é o papel do tribunal. Veja, assim, a gente faz na base de 400 atos de concentração, 450, sobe 25 para o tribunal, lá tem 7, a gente é 1. A superintendência acaba afunilando tudo lá. O tribunal é, inclusive, uma instituição dentro do CAD que tem a capacidade de aprofundar as análises feitas pela superintendência. É isso que o tribunal tem que fazer. Eu acho que o papel do conselheiro, quando eu estava no conselho, era exatamente esse, pelo menos era o que eu procurava fazer quando era conselheiro. Eu vou fazer, muitas vezes, o que a superintendência não teve tempo de fazer. Você tem uma série de coordenações, tocando uma série de processos, investigando 400 casos ao mesmo tempo, enquanto o conselheiro tem a possibilidade de se debruçar por um maior período, dentro de um caso só, e mergulhar nesse caso para poder corrigir eventuais falhas que a superintendência possa ter cometido. Então, não há problema, ao contrário, eu acho que esse é o sistema, e eu acho que esse sistema é extremamente importante. O que eu fico desconfortável é quando a avocação é carente de fundamentação técnica concorrencial específica, ou quando ela é avocada porque o CAD foi instrumentalizado ou porque simplesmente resolveu se avocar, mas não tem muita razão concorrencial. Aí eu acho que é ruim para o CAD, é ruim para quem avocou, é ruim para o tribunal e é ruim para o mercado, especialmente para a sociedade como um todo.
Alexandre, muito obrigada. Nós chegamos ao fim, já até ultrapassamos o tempo. Eu queria agradecer muitíssimo aos palestrantes, Rafik, many thanks, Cristina, Maureen. It was a great pleasure to have you here today. And again, I hope to see you soon on a live event. Alexandre, muito obrigada pela tua participação, pelas tuas colocações sempre muito claras, oportunas e esclarecedoras para todos que estão aqui. Muito obrigada à audiência. Tem algumas outras perguntas, eu peço desculpa para as pessoas que fizeram perguntas que não foram endereçadas, mas acho que quase todas foram endereçadas ao longo do painel. Muito obrigada, bom dia a todos.